Well, hi, everybody. I'm Hana Kern. I'm going to be talking to you today about disability accommodation in the workplace. This is a very tricky area. As many of you probably already know, accommodation requests come in all shapes and sizes. My goal today is to cover accommodation requirements generally, and then also do a deeper dive into some specifics, hit some best practices for you, and then if we have time today, wrap up with some scenarios. All right, let's start out with just an overview. What is workplace accommodation? The Department of Labor defines that as an adjustment to a job or work environment that makes it possible for an individual with a disability to perform their job duties. Okay, and what kinds of things does an employer have to accommodate? Disability is pretty broadly defined. Definitions are a little different under federal and state law, and we will get into that just a little bit. But just generally speaking, we might be talking about a physical disability, right? This is kind of the low-hanging fruit. Oftentimes, these disabilities are easy to identify. Somebody might, for example, use a wheelchair or be sight challenged or hearing challenged or have another physical ailment that's readily apparent. There are also all kinds of behavioral health issues that need to be accommodated, and we are seeing more and more requests relating to behavioral health these days. Mental health issues, ADHD, depression, anxiety. Some of these may require accommodations in the workplace that may seem a little unusual at first blush, but I want to encourage you, don't dismiss those outright. We really need to consider those and approach them really with an open mind. Substance abuse may, under some circumstances, require accommodation. Sexual assault victims, domestic violence victims may require accommodation. Religion is another area that requires accommodation. I'm not going to be talking about that today, but I just want to draw that to your attention so that you're aware. One of the questions that I frequently get is, well, what about family? What if someone wants an accommodation, not because they have a disability, but because they have a family member or someone else with a disability? So technically that is not included in the ADA. Now, there are other laws that of course do protect those folks. However, the ADA does prohibit discrimination based on association with a disabled person. And this could support a claim for failing to accommodate when someone's need is to care for a family member. And so what employers really do need to do is take a broad look. Engage in a process with the employee. It's called the interactive process. You're probably familiar with that term. And just consider what options might be out there. The law contemplates that you will have a back and forth dialogue, that you will engage with the employee and potentially their healthcare provider to determine what might be a reasonable accommodation which will allow them to perform the essential functions of their job without imposing an undue hardship on your business. So to which workplaces does the law apply? Again, a question we often see. The laws don't apply to all workplaces, but there's a but here as well that I'll get to. The Washington Law Against Discrimination, by its terms, applies to workplaces with 8 or more employees. On the federal level, the Americans with Disabilities Act applies to workplaces with 15 or more employees. However, there could be a violation of public policy even for smaller employers. Washington courts have held that discrimination on the basis of disability violates a clear mandate of public policy. And accordingly, Washington courts have held that even an employee in a smaller workplace can bring a disability discrimination claim. So even employers with fewer than 8 employees should sit up and pay attention. So specifically looking at which laws apply, on the federal level, we have the Americans with Disabilities Act. On the state level, we have the Washington Law Against Discrimination. And don't forget that there may also be local ordinances which may apply. So these laws are similar, they are not identical. We are going to be talking about the interactive process and talking about some best practices that generally apply across the board. All right, so let's start with federal law. A plaintiff that wants to bring a claim under the Americans with Disabilities Act has to show that they are a qualified individual with a disability, as that's defined, that their employer had noticed, that is, was aware of the disability and the need for accommodation, and that they can perform the essential functions of their job with a reasonable accommodation, and finally, that the employer refused to make the reasonable accommodation. Under the ADA, an individual with a disability is someone who has a physical or mental impairment that substantially limits one or more of his or her major life activities, or someone who has a record of having such an impairment, or even someone who is regarded as having such an impairment. Okay. A qualified individual means someone who has the skills, experience, education, and other job requirements. So the point there is they have to be able to do the job. It doesn't mean that you have to give a job to someone with a disability who isn't otherwise qualified. Doesn't mean that someone, for example, who's not an engineer would have to be given an engineering job if they have a disability. Another part of qualified means that they can perform that job either with or without reasonable accommodation. All right, here's state law. So under state law, an employee has to show, in order to maintain a claim, that they have a disability or that they are perceived to have a disability, that they are qualified, that is, they can perform those essential job functions either with or without accommodation, that the employer is aware of the disability, and then failed to reasonably accommodate. So under Washington law, the definition of disability is just a little bit different than under federal law. It is the presence of a sensory, mental, or physical handicap. And it also includes circumstances where a sensory, mental, or physical handicap is either medically cognizable or diagnosable, exists as a record or history, or is perceived to exist, whether or not it really does exist. So here's one important difference between Washington state law and the federal law. Unlike the federal ADA, the disability does not need to substantially limit a major life activity. So under state law, we have a broader definition than we do under federal law. So what is a reasonable accommodation? It is one that allows the employee to perform the essential functions of the job without placing an undue hardship on the employer. Some of the examples in the Washington Administrative Code are things like something that will enable the individual to have equal opportunities in the workplace, something that will enable them to properly perform those essential job functions, or something that will enable them to enjoy equal benefits, privileges, or other terms of employment as their colleagues do. So I want to go over some important things to know, and this is just kind of a variety of things that I think it's very important for you to keep in mind as you work through accommodations for employees that may need them. So first of all, once an employer is on notice of something that's going to require accommodation, the employer has a duty to inquire about the nature and extent of the impairment. This is geared toward finding out how the impairment impacts the employee's ability to do their job. So this can be a challenging area in how to do this inquiry, because you really don't want to be doing a deep dive into the employee's medical issues, really only to the extent necessary to engage in the process and determine the types of accommodations that might work. The employee has a duty to cooperate with the employer to explain the nature and extent of the impairment and what their limitations are. So one way to think about this is really your focus needs to be, what are the limitations placed on this employee by the impairment? You really don't need to know all the ins and outs of their medical condition. So as I stated earlier, the employer has to provide a reasonable accommodation unless the employer can show that accommodation would impose an undue hardship. What is an undue hardship? This varies from case to case and from employer to employer because it is considered in light of the employer's size and resources and their disruption to business. For example, something that might be reasonable to a large employer in the region or even a national company may not be reasonable if it is asked of a small mom and pop coffee shop on the corner. So it really is fact specific. Again, turning to the Washington Administrative Code, the code says that things to be considered in determining whether there is an undue hardship are things like the size and resources of the employer, whether or not this cost could be incorporated into some kind of planned remodel. So if the accommodation would require you to change up your workplace, could this be part of some work that you're doing anyway? And other appropriate considerations, which is that big catch-all. And one of the things that people sometimes misunderstand is they think that if it's going to cost them money, they don't have to do it. And that's not the case. The expectation is that an employer will potentially need to spend some money to accommodate an employee. Again, what that looks like is determined on a case-by-case basis. Another important thing to know is that there may be multiple possible accommodations that will do the trick, that will allow that employee to perform those essential job functions. If that's the case, the employer gets to pick. You get to pick. So I've seen a number of situations where an employee believes that they get to dictate what accommodation they get, and that's not the case. As I mentioned earlier, the process is meant to be interactive, and if the result of that process is that there's more than one possible accommodation that will meet the requirements, then the employer gets to decide which one to use. All right, next, turning to doctor's notes, medical documentation. Big picture, generally speaking, you can require medical documentation for an accommodation. Now, that's not to say that every accommodation requires a doctor's note, and really it's not something you need to just have as part of your checklist. There may be some accommodations that are very simple and it's apparent what the employee needs, and you can move forward without a doctor's note. But if you need one, if you need that to find out more details about what their limitations are, you need to communicate with a healthcare provider, you can certainly do that. And the focus there needs to be on what are the employee's limitations. As I mentioned earlier, you want to be asking about what activities are limited, the extent to which impairment limits their ability to perform certain functions, and it can also be used to substantiate why and how the requested accommodation will allow the employee to perform those essential job functions. In other words, if they're asking for something that doesn't really seem to match up with what the limitations are, you can do a further request into that to find out how what they're asking will let them do their job. You can request return to work certification. You can request recertification if the accommodation process is lengthy. And again, that's determined on a case-by-case basis. You can't be requesting it all the time, but you can request it at reasonable intervals. You can request a second opinion if you have a reasonable basis to doubt the validity of the first, or if there's insufficient information in that first opinion and you just can't get any more. The best practice really is to try to go back to the provider first if things aren't clear and get clarification from them. Next, the duty to accommodate is continuing. This is not a one and done situation. So when you have implemented an accommodation and things seem to be going well, that's great. But you do want to check back periodically because things can change. And if things do change and that employee needs additional accommodation, you can't just say, sorry, I already accommodated you, we're done. It's an ongoing duty. Another thing to think about too is the duty to accommodate is separate from FMLA protection. And where this sometimes comes up is the employee may have exhausted their rights under the FMLA. And so now you're thinking, okay, they just have to come back to work. And if they can't, they're out. That's not the case. That duty to accommodate could still exist, even though they don't have any more protections under the FMLA. All right, let's turn to a few best practices. First of all, I've mentioned the interactive process. As I noted, this contemplates back and forth. This contemplates you reaching out to the employee engaging back with you, brainstorming different ideas, trying to figure out, what can happen here in the workplace that will allow this employee to do those essential functions. Next, essential job functions. One of the first steps really that I recommend when you're faced with an accommodation request is figure out what are the essential job functions and which ones are non-essential, because the law does require you to consider reassigning some of those non-essential functions to someone else if that's required to accommodate this employee. So by recognizing and writing down what those essential job functions are, that will help you determine whether the person in question can perform what are the essential functions. Modifications to accommodations. As I mentioned earlier, it is a process. So you may think you're done, but you may need to re-engage in that interactive process. Termination of employment. The law is that if there is no reasonable accommodation, which will allow the employee to perform the essential functions of the job, then they can be terminated. But that is something that I strongly encourage you to work with counsel on before you go to termination. We want to make sure that you are protected in the event that employee brings a claim. So, we want to make sure that that process has been robust and that you really are at that place where termination is appropriate. I want to touch on training briefly. It is important to train the people in your organization that might be getting those accommodation requests on how to handle them. You don't want to be in a situation where an accommodation request came in without you ever knowing about it. The person's manager decided they couldn't accommodate that, and if they have the power to fire somebody, that they just fired them. So it's really important for those folks in various leadership positions in your organization to just be aware, generally speaking, of accommodation requirements. It's a great idea to have a requirement in your organization that any accommodation request be brought to HR or to management or whatever the case may be. And just as a quick side note, it is not only a formal accommodation request from an employee that triggers this requirement. It is any time that, as the employer, you are aware of a need to accommodate. And as far as best practices go, I always like to touch on documentation. And usually that is whatever topic I'm talking about. For those of you that have worked with me or my colleagues, you know that one of the favorite things that we love to say is document, document, document. And this is very true in accommodation. And it's because if you do have a claim down the road, you'll want to be able to show that you engaged in that interactive process. And the best way to show that is to show, emails going back and forth, maybe your notes from the meetings that you had regarding accommodation. All right, let's just talk briefly about when an accommodation request is unreasonable. We talked about undue hardship. So, we talked about expense alone necessarily doesn't create an undue hardship. The burden is on the employer to prove undue hardship. So just because it's an additional cost, didn't dismiss it outright. It is unreasonable to remove essential job functions. You don't have to let them sit around and do nothing, basically. It is also not reasonable for you to fire someone else, displace another worker, cause undue hardship to other employees. And of course, you don't have to create a job for an employee as an accommodation. So just briefly to go through the types of accommodations that we often work with, something that modifies the workspace: physical accessibility, ergonomic office furniture, lighting, noise reduction, maybe masks or social distancing. As far as communication tools, depending on what the disability is, you might consider whether someone would do better if they had written versus auditory versus visual instructions or communications. Maybe rather than instructions being given verbally, communications happen by email. Meeting accommodations. Maybe someone needs written agendas for meetings. Maybe they need recaps of meetings. Closed captioning. Could you schedule meetings at different times of day? Reassignment is something to be considered. Is there another job the person can perform? Something temporary or permanent? And then scheduling support. Could they go part-time? And really, the question marks are there because I want you to be creative here. This is where you should just be thinking outside the box. All right, and just briefly, I was hoping to cover some scenarios or case studies with you, but I'm not sure that we're going to be able to get to very many of these. I'll just let you know that leave as an accommodation can be reasonable. Indefinite leave is not considered reasonable. So if someone comes in and says, I'm going to be out and it's going to be forever, I don't know how long, that's not considered a reasonable accommodation. Animals, there is a difference between service animals and emotional support animals. It's complicated, and of course you have to consider the impact on the other folks in the office, but it's not to say that having some kind of animal along is an unreasonable accommodation. Anxiety brought on by a coworker. We're seeing this a lot lately. How do you manage that? Can you separate folks? Can you reassign folks? How about what I alluded to earlier, a rogue manager firing someone who makes an accommodation request? Try to avoid that with good training processes. Finally, employees who refuse to cooperate, and this does sometimes happen. They may not recognize that they have that obligation to engage with you, and you do want to let them know that they do have that obligation, and hopefully that employee will cooperate. But there is law out there saying, if the employee refuses to cooperate as an employer, there's not a whole lot you can do, and you may not have your feet held to the fire in that case. All right, everybody. That is all the time I have for today. This is a complex area, and we welcome your questions either to the extent we can get to them today, or you can reach out to any one of us.